Now it's time to talk about revocable living trusts. Revocable living trusts are sometimes known as will substitutes, and they're often thought of as ways to avoid probate. You might remember when we talked about probate property. That's the property controlled by your will. And we also talked about the non-probate property. That's the property that's not controlled by your will. We looked at the different types of property described on this slide. The property on the right-hand side of the slide are the most common types of non-probate property. If you look down at the bottom of the list of non-probate property, you'll see revocable living trusts. You might recall that when we were talking about non-probate property, I said that this was property which, by the terms of an agreement or contract, will pass to the beneficiary under the terms of the contract when the owner of the property passes away. The beneficiary will receive the property as a matter of rights given to the beneficiary by the terms of the agreement or contract. The right to receive the property was built into the contract that governs that type of property. So we talked about life insurance policies, for example, where the life insurance death benefit passes to the person named as the beneficiary on a beneficiary designation form, which is part of the life insurance policy, which is actually a contract. The life insurance policy says that the person named on the beneficiary form is the person who has a right to the life insurance death benefit. So the person who receives the death benefit receives it as a result of the provisions in the contract that relate to that type of property. Revocable living trusts are similar. The people who receive the property in the revocable living trust are the people who are identified in an agreement as the beneficiary. Keep in mind that wills are effective only at death. Therefore, they can do very little or nothing at all while you're alive. Also, before the will is effective, after you pass away, it has to be taken down to the probate court, and the court makes a finding that it is, in fact, your last will and testament. At that point, the instructions in the will kick in, and the executor of the will is granted the power to carry out those instructions. So the will really can't do anything at all for you while you're alive. When it comes to a revocable living trust, however, remember that it's created by an agreement. It's an agreement between you as the person who establishes the trust and your trustee, and it's effective while you're alive. Earlier we talked about how trusts work, so I won't go into great depth now. I'll just say that because it's established by an agreement between you and the trustee right now while you're alive, it can deal with lifetime issues. It usually includes provisions that deal with how the property is to be managed while you're alive and just after your death. So after you pass away, the assets in the trust are disposed of by the terms of the trust. There's no need to ask the probate court to grant authority over the assets in the trust because the terms of the trust already grant that authority to the trustee under the revocable living trust agreement. If you own everything in the trust, that is, if the trust owns everything you have, there wouldn't be a need to go to the probate court at all to have the will probated. In that sense, probate can be avoided. That's why the revocable living trust is thought of as a probate avoidance technique. How do you establish a revocable living trust? First, you prepare a trust agreement. It looks very much like any other written agreement, but that's not the end of the story. It's best to prepare other related documents, including a will. Even though you have a trust agreement, and even though you might be intending to transfer all your property to the trust created by that agreement, you still need a will because it's likely that you'll leave something out. You'll forget to put something in the trust, or some type of property will be acquired after the trust agreement is established, and you'll forget to put that in. So you prepare the trust agreement, and then you transfer assets to the trustee who is identified in the trust agreement. Keep in mind that if one of your key goals is to avoid probate, that would mean all your assets must be transferred to the trust. But there are exceptions to that, and I don't want to mislead you into transferring all your IRAs and your 401k accounts and assets of that sort to the revocable trust, because that could create quite an income tax disaster. but the idea is if you're going to avoid probate, the revocable living trust will own all the assets that you would have considered probate assets before you set up your revocable living trust. That normally would not include retirement plan accounts such as IRAs. You would usually name beneficiaries for such accounts on beneficiary designation forms. You might make the trustee of the revocable trust the beneficiary of such retirement plan accounts, but there are some important income tax reasons why you might not do that. All those issues need to be discussed while you're setting up your revocable living trust. One of the first things the terms of the revocable living trust will do is identify the trustee. The trustee can be pretty much anybody you want. It's not unusual for you to be your own trustee of your revocable trust. You might be the only trustee of your own trust, or you might identify your spouse as a co-trustee, or maybe you'll name a child as a co-trustee, or maybe you don't want a co-trustee, so you might have yourself as a sole trustee, and perhaps you'll name somebody and designate them as the standby trustee. That's the person who would be trustee if you can't serve for some reason. For example, if you become incapable, you'd name a standby trustee to act in your place. The agreement goes on to include the trustee's promise to manage the trust property, take care of the trust property, and dispose of the trust property according to the instructions in the agreement. Typically, the trustee will pay the income and the principal of the trust to or for the person who's creating that trust. That's the grantor. And also, the terms of the trust could include other people as beneficiaries. So it's not unusual for the trust agreement to say that if the grantor becomes incapable, then the grantor's assets and the income on those assets could be used for the benefit of other family members. This is especially helpful if the grantor is providing support for somebody else and the grantor is worried that his incapacity might disrupt that support. Other important terms of the revocable living trust include the power in the grantor to revoke the agreement, and also the power in the grantor to amend the agreement, and the power in the grantor to remove the trustee and appoint a successor trustee. The grantor typically controls all investment decisions while the grantor is alive and capable, and the terms of the trust typically say that at the grantor's death, the trustee distributes all the trust property to the beneficiaries as directed in the agreement. In the next segment, we compare the revocable trust plan with the alternatives.